Imagine you're accused of stealing grain in ancient Babylon. There's no lawyer for you, no jury of your peers, no courtroom with air conditioning. Instead, you stand at the edge of a river. The priest looks at you and says, "Jump in! If the gods want you to live, you'll swim." That was justice. And honestly, it gets weirder from there. Today we're looking at how ancient civilizations put people on trial, and some of what they did will shock you, some will impress you, and one of them actually gave us the foundation of modern law. Let's start about 4,000 years ago. In ancient Babylon, one of the earliest civilizations we know, had a formal legal code. King Hammurabi created one of history's first written law codes, 282 laws carved into an 8-foot stone pillar. And yes, it included an eye for an eye, but it also had actual trial procedures. If someone accused you of a crime, the case went before judges, usually priests or elders in the community. Both sides presented their story, witnesses were heard, evidence was weighed. But here's where it gets interesting. If there was no clear evidence, if it came down to your word against someone else, the judge could send you to a river ordeal. Drown? Well, the gods had judged you, and your accuser could actually inherit your property. The wild thing? Historians believe this actually worked as a deterrent. False accusers were terrified of being punished themselves if the accused survived. Justice through terror, basically. Ancient Egypt had a surprisingly sophisticated court system, and it was one of the few ancient societies that treated men and women as legal equals in court. Cases were heard by a local council called the Kenbet, made up of respected officials and community elders. People could submit written complaints. Witnesses gave sworn testimony. And if you lied under oath, you invoked the wrath of Ma'at, the goddess of truth and justice. Egyptians believed the gods watched every trial. For serious crimes, the case escalated to the great Kenbet, presided over by the vizier, the pharaoh's right-hand man. The punishment for the worst crimes wasn't just death. It was the erasure of your name from all records. In Egyptian belief, that meant the destruction of your soul. You wouldn't just die, you would cease to exist forever. If that doesn't motivate people to behave, I don't know what does. Now here's where things start to look recognizable. Ancient Athens around the 5th century BCE invented something radical, a jury of ordinary citizens. The Athenian court, called the Heliaia, could assemble a jury of 201 to 501 people, sometimes more for major cases. These weren't legal experts. They were randomly selected male citizens. No judge decided the verdict. The people did. Each side, prosecution and defense, was given a measured amount of time to speak, tracked by a clepsydra, a water clock. When your water ran out, you stopped talking. No exceptions. After both sides spoke, jurors voted immediately, no deliberation. They used bronze tokens, one side solid for innocent, one hollow for guilty. Tokens were dropped into urns. The votes were counted. Majority ruled. The most famous trial in Athenian history? Socrates, 399 BCE, charged with impiety and corrupting the youth. He argued his own case famously, defiantly, without apology. The jury voted 280 to 220 to convict. Then they voted on his punishment. He was offered exile but refused. He chose death by hemlock, justice or persecution. Still debated today. Rome took Greek ideas and built an entire legal machine around them, one that directly shaped the laws of almost every Western country today. The Roman court system had professional prosecutors and defense advocates, essentially lawyers. They argued publicly, often in the Roman Forum, in front of crowds. Winning a high-profile case could make your entire career. Cicero, the greatest orator in Roman history. Criminal trials were heard by a quaestio, a standing jury court, with a presiding magistrate and a jury typically drawn from the senatorial or equestrian class. The accused had the right to speak, to call witnesses, and to confront accusers. Defendants could also bring character witnesses, sometimes dozens of them, to vouch for their reputation. And Rome introduced something crucial, the idea that the burden of proof lies with the accuser. A incumbit probatio qui dicit, proof lies upon the one who affirms. That principle is still in every modern legal system on earth. But the structural DNA of what we call due process? It starts here. Not every ancient culture relied on logic and testimony. Many turned to the gods directly through pain. Trial by ordeal appeared across cultures. In ancient India's Dharmashastra legal texts, in Germanic tribes, in medieval Europe, and in parts of ancient Africa. The idea was simple. Divine forces would protect the innocent and expose the guilty through a physical test. Common ordeals included holding a red-hot iron bar and walking 9 paces. Your wound was bandaged and checked 3 days later, if healing cleanly, innocent. If infected, guilty. You could also plunge your hand into boiling water to retrieve a stone, or be bound and thrown into a blessed pool if you sank innocent. If you floated, you were rejecting the holy water, which meant guilt. We didn't invent fairness, we inherited it, and the least we can do is understand where it came from.